Alderman Tabaris.
Yes, I just want to start by saying that it is just very shameful, just shameful that the Fraternal Order of Police, FOP, was excluded from serving on the panel to answer questions from aldermen. This is especially after they were told that they can speak. This is very one-sided, and it's a slap to the face to the police officers and organized labor. I'm going to move on to my questioning because we've had discussions about the Illinois Public Labor Relations Act. I know we had some discussions, but I have a few questions because this is the Workforce Development Committee, and it's tasked with considering matters regarding public sector unions. For the record, isn't it true that Section 8 of the Illinois Public Labor Relations Act requires arbitration to be a term in the collective bargaining agreements covering police officers?
Yes, unless the parties agree otherwise.
And isn't it the case that Section 2 of the Illinois Public Labor Relations Act ensures that police officers are entitled to interest arbitration as a right given in lieu of the fact that they are prohibited from striking?
Yes,
And doesn't Section 15 of the Labor Relations Act make clear that this law shall supersede any other laws or local ordinances that deny or limit these employees' right to arbitration?
yes,
The question of arbitration for police is not a matter of granting a new avenue to police officers. It is about correcting a wrong based on the fact Chicago has been using a disciplinary process for police officers for years in violation of state law. The law is clear. When the city of Chicago created the Chicago Police Board, it did so in violation of the Illinois Public Relations Act, Section 15 and page 4 of the Interest Arbitration Award could not make it any clearer. Every police officer who has had his or her career impacted by a decision by the Chicago Police Board has been subjected to an illegal process set up by the city to impede their rights as a worker, just because he or she is a police officer. Firefighters are not brought before an illegal board. Laborers are not brought before an illegal board. Only police officers. I understand that some have expressed concerns over issues of transparency regarding the arbitration process. I would love to see these same individuals make speeches and protest for more transparency regarding the names of the 470 sexual assault complaints made against Chicago public school employees. Because the fact of the matter is, there is a double standard here. And the process we have in this city regarding police discipline is not the product of well-intentioned public servants. It is the product of political pandering, witch hunts, and scapegoating. And let's be clear. If an officer is accused of something illegal, he or she would be subjected to criminal proceedings like any other individual, mugshot and all. We are talking about the mob demanding names and addresses of police officers accused of department infractions so they can know where they live, know where they work, and know where their children go to school. As we gear up to host the Democratic Convention, I urge my colleagues to adopt this measure and stop the practice of running an illegal process that tramples on the due process of these members of organized labor, because each day we continue with the current illegal process. We can never call ourselves a city that protects workers' rights, but actually tramples on those rights to score political points. I just want to finally say that all other union jobs in this city can already go before an arbitrator. All this does is treat police officers like everybody else. You cannot be against this agreement and call yourself pro-union. Every alderman opposed to this is showing their true biased anti-police colors. It's a shame that so many who claim to be pro-labor decided to voice opposition to this agreement. It also sends a message to other unions that you cannot trust the city of Chicago to be negotiating in good faith when the mayor opposes his own deal. Thank you.